My Lord, first oral question, Lord Young of Cookham.
I beg leave to ask the question standing in my name on the order paper.
My Lords, the Government published the response to the Small Payments Consultation on the 28th of February, and a copy of that response is in the library. The Government considers it is better to improve the processes of the Court of Protection rather than legislate for a separate small payment scheme for adults lacking mental capacity.
I'm grateful for that reply. It's a happy coincidence that after waiting 13 months for a response, one appeared 24 hours before this question was reached. I very much regret that the Government is not proceeding with the small payments scheme. We now have the absurd position that a parent of an 18-year-old with a learning disability can receive tens of thousands of pounds rightly from the Department of Work and Pensions after a home visit to make sure that the money is being correctly applied. But the same parent of that same child cannot access the Child Trust Fund, average sum involved £2,400, without going through a lengthy, bureaucratic and at times expensive process involving the Court of Protection, a process that deters many parents from going through it. My Lords, if the Department of Work and Pensions is satisfied that the parent can act as an appointee, looking after tens of thousands of pounds of taxpayers' money, why can't the MOJ agree to a similar process, enabling that parent to access the child trust funds, which have been provided by the family itself?
My Lords, on the specific question that the noble Lord asks, and I do recognise that there is a problem in this area, and I'm grateful to him for raising the problem. On the specific point of the DWP payments, the Government sees an important distinction between public money being paid for the living expenses of a dependent adult lacking mental capacity on the one hand, and the way we deal with the private property and capital of an adult lacking mental capacity on the other hand. In relation to the latter point, the Government is extremely reluctant to undermine the general principle of the 2005 Act that anyone wishing to take decisions on behalf of an adult lacking mental capacity must be authorised by the Court of Protection.
My Lords, my Lords.
My Lords. Firstly, I'd like to pay a tribute to the noble Lord Young for his tenacity on this issue. Does the Minister agree with me that while the vast majority of parents and carers will act in the best interests of their loved ones, there still needs to be in place proper processes to protect the assets of vulnerable people? Now, the Government has said, and the Minister repeated just now, that it intends to improve the processes going through the Court of Protection, and specifically the processing times and simplifying court forms. Can the Minister say what progress has been made in this regard?
Well, Lords, yes, and I'm able to fully agree with the noble Lord Ponsonby. We identified two problems, my Lord. The first was the clunky, if I may use the expression, procedures of the Court of Protection, and the second was a general lack of awareness of the general law under the 2005 Act. In relation to the first, the Court of Protection has in the meantime been digitalised, and as from this month, anyone can apply online for the relevant authorisation known as a deputyship. The relevant pilot reduced waiting times from 24 weeks to 8 weeks, and the court forms are being worked on at the moment with a view to making them simpler and more user-friendly. So there is good progress at the level of the Court of Protection. In relation to the second problem, which is general awareness of the need to observe the 2005 Act, we're in the process of a cross-government consultation to improve and raise public awareness.
My Lords, some child trust providers, such as One Family and Foresters Financial, have developed a simplified process, working with families and using the DWP appointee scheme as a proxy to protect against fraud or abuse. In the recent MOJ consultation on this issue, 87% of the respondents liked this way of working. Why has the government rejected it?
My Lords, essentially, there was general support for the idea of some sort of scheme, or at least some simplification of the process, but no consensus on what safeguards we should have. In particular, most banks and financial services companies did express concerns about what they would have to do to carry out the relevant checks. There would be quite a small demand. It would be quite expensive for most institutions to provide the relevant service. And in those circumstances, the government decided this was a case where we should avoid legislation and work to improve the present system.
Does His Majesty's government, I beg your pardon, know how many of the 6 million child trust fund holders lack capacity? Because if this is not known, how can fund providers be sure it's right to release funds to third parties? And I ask this question because there is concern, my Lords, that some fund providers are not as diligent as they ought to be in this regard.
I cannot, my Lords, comment on how fund providers operate their relevant systems. The number of adults holding child trust funds who have become adults who lack capacity is quite small. It's thought to be around 1 to 2%, but it's nonetheless significant, and the risk of abuse is quite prominent.
My Lords, having recently been alongside someone who is had tried to be an appointee, could my noble friend the Minister please talk to DWP about this system, because it is not a simple system to become an appointee for somebody under DWP, and is there not then a case for basically not duplicating the processes, and that once you get through the appointee hoops, which are considerable, you should actually just automatically be a deputyship and just do it once?
Well, Lords, the government is extremely reluctant at the moment to confuse two things. One is the processes by which DWP works, and the other is the legal process by which an adult lacking capacity can have somebody else act on their behalf. And that is a job for the Court of Protection. It is not just a question of child trust funds, although that's an important issue. This can go on throughout a child's life, and it's quite likely that a child lacking capacity who reaches the age of 18 will continue to lack capacity for many years to come, and there will be important decisions to take, and that really should be supervised by the Court of Protection and not by the DWP.
My Lords, it's been a privilege to work with Lord Young of Cookham on this really important issue. When I led on the implementation of the Child Trust Fund, prior to the 2005 Act, we never foresaw that this situation would arise. Isn't it a scandal that the cost to the financial institutions should take priority over the cost to these young people who can't access their funds? We understand about the Mental Capacity Act, we understand the dangers and the safeguards necessary, but after what's happened with the magistrates' courts over the issue of prepayment meters, can anybody really believe that putting the court system before putting personal support to parents and young people should take precedence?
Lords, it's not simply a question of cost to financial institutions. There's a whole range of problems here, and an essential tension between protection against abuse and simplicity of process. And in this area where it is possible to have very different views, the government feels that the principle established in the 2005 Act, placing the responsibility on the Court of Protection, is the right place for that responsibility.
My Lords, I said when the noble Lord Cookham, Young of Cookham raised this, that he put his finger on an absurdity, and it was quite clear that I was right on that one, at least. Can the government give us some undertaking of what they are doing to make sure when parents put money into funds for their children's future, that they are told all the things they have to do to make sure the child can access it accurately. Because we're saying there should be greater awareness will not help. You need one place to go saying this is the legal process.
Well, Lords, the government will do all it can to raise public awareness. If, for example, DVLA can inform me regularly that my driving licence needs to be renewed when I get to 70, surely we can have some similar process when a child reaches the age of 18.
Minister, for actually answering the questions that are put to him rather than reading from a brief before him. Is there any way he could pass that skill on to his colleagues?
My Lord, my colleagues are already skilful enough.
Second oral question, Baroness Cousins.